Hi everyone, and welcome to our 2023 APAC and India Compliance webinar. My name is Michael, Marketing Manager for HireRight APAC and India, and I will be your moderator for today's webinar. So before I hand you over to today's presenter, Caroline Smith, VP Deputy General Counsel of HireRight, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple widgets you can use, and if you encounter any audio or visual issues, please refresh your browser window by pressing F5 on your keyboard. You may also click on the Help widget at the bottom of your console. It has a question mark icon and covers common technical questions. We will be putting all attendees on mute throughout the webinar. To ask questions, please submit them using the Q&A chat box at the bottom of your screen. You may submit questions anytime during the webinar, and we will try to answer these at the end. And if we run out of time, we will get back to you after the webinar. At the same time, we will appreciate your feedback regarding today's session, so please take a moment to complete our short survey. You can access the survey by clicking on the survey widget at the bottom of your screen. Last but not least, this webinar will be recorded, and the recording will be shared in a few days via email. So without further ado, I will now hand over to Caroline to kick off today's session. Over to you, Caroline.
Thanks, Michael, for the intro, and thanks everybody for taking time out today to join us to talk about compliance in APAC and India. Now, before we get started, I do need to draw your attention to the HireRight legal notice and our disclaimer. These materials are only prepared for informational purposes and, of course, are not a substitute, and you shouldn't use this material or these slides for any legal advice. And with that out of the way, let's move on to the agenda. So we're going to split the webinar into two parts today. In the first, we're going to cover some regional compliance updates, taking you on a quick journey around Southeast Asia and Greater China. And then we're going to really focus in on two new emerging laws, first being the Privacy Bill and the impact on pre-employment screening in India, and then a review of some of the privacy reforms proposed in Australia. In the second part, we're going to focus on one of HireRight's new products, social media. And as Michael said, please do drop any questions that you have in the Q&A chat box, and these will be picked up. And if we've got time, we will answer the questions at the end of the presentation. So we're going to start our compliance tour of the region in Southeast Asia, where the privacy landscape is ever evolving, as can be seen from the privacy law updates that are set out on this slide. But before we get into this detail, we did want to just recap on some milestones at the end of 2022, because there are some new implementations of laws that we've been waiting for some time, those being the Indonesian Personal Data Protection Law and the Thai Data Protection Law, and Singapore also issued a couple of updates. So quickly, the Indonesian Personal Data Protection Law, or the PDPL, came into force on the 17th of October 2022. However, the regulator is not expecting full compliance until October 2024, which gives you plenty of time to review and adapt any practices where needed. Though, having said that, as we're currently moving through 2023 at a great pace, we do recommend that companies start reviews soon, and we're, of course, doing the same. Now, in respect to the PDPL, the GDPR has, of course, had an influence on the structure and principles that underlie that law, and anyone with a familiarity with the GDPR will already have a really good base understanding of what's required. There's always localizations, of course, for local needs within jurisdictions. But some of the key takeaways that we wanted to draw out are that the law does have extraterritorial effect. It's a little bit more limited than in the GDPR. It applies within and outside of Indonesia if the processing has legal consequences in Indonesia or affects Indonesian citizens located outside of Indonesia. Now, arguably, background screening could come under those definitions. So we'll be making sure that services comply with all of the requirements. There's data subject rights under the PDPL, and again, there's many that are similar to those contained in the GDPR. However, there is one right that is distinct and unfamiliar to us, and that's the right to restrict data processing. Now, we're considering if this right is going to have any impact on our services, and we're going to be following any commentary on this topic really closely. The PDPL does restrict data transfers and only permits them in two limited circumstances, and that is, firstly, if the data is transferred to a country that offers the same level of protection as would be afforded under the PDPL, or with the consent of the data subject. Now, for all of you that use our services in Indonesia, you don't need to worry. We already have that data subject consent built into our platforms, so we are already compliant in that respect. But of course, what we're also doing is analysing the UK GDPR, because Indonesian accounts are processed off our UK instance, against the requirements in the PDPL to show that the country does offer the same level of protection that the PDPL affords. And that will again help provide evidence. Now, it may be during the course of the evolution of this law that we look at rulings of adequacy, etc. as well, but as we see in the EU, but we'll keep you posted on that. And then finally, of course, the PDPL does permit the Indonesian regulator to impose fines. Now, those fines are 2% of your annual revenue if you're a data controller. And also there are criminal sanctions, so you can be imprisoned for up to 6 years, which seems a long time, or additional fines of up to around 385,000 US dollars. Now, the other big news in region last year was that finally the Thai Data Protection Act 2019, PDPA, came into force, and that law has now been enforced for just over a year. And again, we can see the influence of the GDPR in that new law, though of course we see some interesting differences. So one example would be in respect to anonymisation of data. Additionally, to the PDPA, the Ministry of Digital Economy and Society and the Personal Data Protection Committee have released some secondary draft guidelines to clarify the position under the law on key concepts relating to data security and data transfers. And we'll be providing more information around those 2 points in future newsletters and blog pieces. But again, some key takeaways. The PDPA in Thailand has extraterritorial effect. It is incredibly similar, if not identical, to the extraterritorial effect that we see in the GDPR. So it applies to the collection of data to entities inside and outside of Thailand if goods and services are being offered to individuals, or the processing relates to the monitoring of that individual's behaviour. And as we found with the GDPR, due to the nature of some of the checks that are conducted, like criminal checks, adverse media, GSEC, we do believe that pre-employment screening falls into that category B, so processing relating to an individual's behaviour. Again, we've got data subject rights, which are incredibly similar to the GDPR, but there is one right that's called the right to restriction, which is very different to those that we find in other laws. And that right is used where it's no longer necessary to retain the personal data, but the individual does require the retention in order for them to establish or exercise legal claims or defend legal claims. And in such circumstances, at their request, the data can be retained, but its use is restricted. And that could be quite interesting in context of pre-employment screening if there's ever any disputes that arise in future with employers. So it'd be useful to look at data retention periods and ensuring that they're a little bit shorter perhaps than a year or 2 years, so that data is in fact already deleted and then no longer capable of being retained. And then finally, of course, there's the fines. It's a common theme with all the new legislation that's coming into force. And in the Thai legislation, civil liability administration fines of up to Thai baht 5 million can be issued. And again, there's criminal liability, but this time only for imprisonment for a period of 1 year or a fine up to 1 million. Finally, the Singaporean authorities issued some amendments to the Personal Data Protection Act. And again, they took effect in October of last year. As most folk on this call will be aware, the most impactful of those amendments was the increase to the financial penalties that could be levied on an organisation. And those fines have increased, so the fines are either 1 million Singaporean dollars, or if the organisation's annual turnover exceeds 10 million Singaporean dollars, 10% of that organisation's annual turnover in Singapore. And the PDPC, which is the regulator, has issued some updated guidance to take this all into account. Now, rolling forwards to 2023, we are continuing to see lots of updates across the region. So the first that we're going to cover is the updates to the Code of Practice on Personal Data Protection in Malaysia. Now, the code aims to set out best practice for a data user to help them meet requirements under the Personal Data Protection Act 2010, again, PDPA. There's a lot of focus in the updated code on the principles under the PDPA, as well as rights of data subjects. But from a practical perspective, the code actually provides examples of what constitutes a consent and also an example of the scope of information required in a processing notice. Now, we've already reviewed what the updated code against the proformas that we provide on our platform, and anyone who is using those proformas can be assured that they already align to what's in the updated code. There's also some useful information on data protection compliance and monitoring included there. But again, anyone who's not using those proformas, it is worthwhile you just checking what your custom consents and notices look like as against that code. In South Korea, who incidentally were the first country to get a ruling of adequacy from the UK back in December last year, the South Korean National Assembly passed a proposal to amend the Personal Information Protection Act of 2011, or PIPA. And that's quite important because South Korean legislation has been deemed to be some of the most stringent globally. So in particular interest for us in background screening, those amendments also include lowering requirements for processing personal information, and also new requirements for processing special categories of personal information, and introduction of rights applying to automated decision-making, and new rules for cross-border transfers. Again, as per Indonesia at HireRight, your APAC accounts are largely on our UK instance. So given there's a ruling of adequacy, there is no need to worry about those cross-border transfer rules. However, if you have a historical account that might still be being processed on the US instance, it might be worth reaching out to your account manager or customer service to talk about whether or not that account needs to be moved over. In other news in South Korea, the Personal Information Protection Committee, PIPC, announced in the end of January of this year that it was going to be releasing an amended version of the Employment Personal Information Protection Guidelines. Now, these guidelines are actually only available in Korean, and we're still going through these and reviewing. And again, we're going to be issuing some further updates on the topic in future newsletters, blogs, and webinars. And of course, if that has any impact on the services, we'll be letting everyone know what changes we're making. In Vietnam, excitingly, we're seeing progress towards a consolidated privacy law. Currently, all the rules relating to privacy are scattered across a number of legislative instruments. But in early February, the Prime Minister of Vietnam signed Resolution 13 NQCP, and that approved a dossier to develop the Personal Data Protection Decree. That resolution also approved the draft content of the Personal Data Protection Decree and assigned the Minister of Public Security to report and consult with the Standing Committee of the National Assembly on that decree. So again, very exciting in Vietnam that we might see a Consolidated Privacy Act. And finally, to Taiwan, there's been amendments to the Personal Data Protection Act, again, PDPA, and they came into force at the beginning of last month. Now, all of these amendments are really intended to act as a deterrent in respect to breach and ensure that entities take compliance more seriously. And what the amendments have done is create a new regulatory body called the Personal Data Protection Committee, and they're going to be an independent supervisory body that has oversight of government agencies and private sector entities. The committee is going to have the power to amend and interpret the PDPA, and it will also play a role in classifying different categories of personal data and setting specific purposes for the collection of that data. The committee is also going to be responsible for issuing guidance to government agencies and those private sector entities on how they can comply with the laws. Additionally, those amendments include new provisions relating to fines, and they've been amended to allow the committee to issue immediate fines on any private sector entity if they do not comply with the provisions under the PDPA. And those fines have increased exponentially. So they've gone from 200,000 to 2 million for non-compliance. And if you then fail to rectify any shortcomings that have been identified, those fines are now 1.5 million as opposed to 150,000. And as we say, that's all intended to act as a deterrent. Moving to Greater China, the Office of the Privacy Commission for Personal Data in Hong Kong published its report on its work and focus in 2022. And that report outlines how the PCPD has been working with the government of Hong Kong to review the Personal Data Privacy Ordinance that was amended back in 2021. Now, that report confirms that the PCPD is going to consider other jurisdictions' legislation alongside the situation in Hong Kong to put forward proposals that are intended to strengthen all those privacy protections. And among other amendments, the report emphasises the need to establish mandatory data breach notification and will empower the Privacy Commissioner to impose administrative fines and introduce direct regulation of data processors. Of course, HireRight as a data processor will be watching that one quite carefully. Now, in respect to timelines, it's proposed that the legislative panel is going to be consulted on all those amendments, and that was due to take place during the second quarter of this year. So we're scouring the internet at the moment for privacy updates on that topic. And then finally, we're going to move to China, and we've seen a lot of activity, and it has to be said that that's welcome activity in relation to data transfers and long-awaited clarification on the position. Now, there's lots to cover here, but due to time, we're only going to look at the standard contractual measures and the provisions that have been released there. So the Cyberspace Administration of China, the CAC, have finally published those standard contractual measures for exporting personal information, or SCM as we'll refer to them, and they were adopted in early February. Now, at the date of adoption, the CAC highlighted that those SCM apply to those entities that provide personal information outside of China, and that those entities must conclude SCM with the overseas recipient of that processed data. Now, there's several conditions that have to be met in order to use the SCM, and crucially, the personal information processors do have to conduct a personal information impact assessment before providing that personal information overseas. The assessments have to focus on the legitimacy and necessity of the processing, the scale, type, and sensitivity of the personal data, and whether the overseas recipient has promised or can implement technical and security measures that protect the risk to personal data being lost, leaked, or tampered with. They also need to consider the impact of local laws of the overseas entity on that standard contract. Now, those SCM entered into force at the beginning of June of this year, and we're working currently with all of our China-based vendors to ensure those SCM are in place and that all of the privacy impact assessments are fully documented. And a few weeks ago, we also received further guidance from the CAC on how those SCM are then to be filed. And there's quite short timescales that are prescribed in the latest guidance once those SCM are executed. So the provisions are pretty robust, and the entity who's actually transferring that data only has 10 days grace post-execution of the SCM to file with the local CAC. And those filings do require several supplementary documents to be included in that filing. The local CAC then has 15 days to review those documents, and they can ask for further information. And that cycle of 10 days and 15 days recommences every time a new request is made. Now, of course, the CAC can reject a filing, but we have looked into this, and all of the guidance that we can see is that folks shouldn't be too worried about the time it takes for those filings to be approved, or if a filing actually turns out to not be successful, because the measures relating to privacy do state that the filings are not a precondition of the SCM becoming effective. So personal information can be transferred outside of China once those SCM take effect, i.e. once the parties have signed them. So that is good news. So at least we can rely on those for now. Again, we don't know how that will translate in practice, but for now, that is the position. So we're going to move on now to a focus on India and the new privacy bill and the impact on background screening. Now, it released its updated privacy bill late last year in November, and it replaces the much maligned personal protection, data protection bill of 2019, after that bill did receive quite a lot of pushback from industry giants. And whilst we've been here before, in as much as that original bill did appear to be on the cusp of being ratified quite a number of times, we hear that this new bill is due to be heard in the monsoon season or session of Parliament, and that starts on the 17th of July, so we're going to be monitoring progress. The new bill is called the Digital Personal Data Protection Bill, and it has to be said that in terms of resources discussing the bill and the attention it's gathered outside of India, it does seem to be a much quieter launch in comparison to that 2019 bill. Now, we suspect that that's partly because the new bill is much more limited in scope than the 2019 bill. The new bill only applies to data that's either collected online or offline data that's then digitized afterwards. Non-automating processing is also excluded from the purview of the new bill. It seems then on first reading that the impact of the bill is going to be quite limited because a lot of records in India remain undigitized. However, Commentary in respect to the new bill does call out that the legislation recognises that it's important that records are digitised and that robust privacy laws are an essential component in achieving this. So it could be said that that new bill provides encouragement to organisations to digitise personal data. And it's certainly the case that collecting or managing offline data in physical form is high, and it's not really terribly sustainable, especially as we live most of our lives online and need to exchange digital records. So if that is correct, that the new bill will have limited impact whilst records remain largely offline, does it have any impact on background screening services in the near term? Well, we actually think that it could. It is true that for most providers of background screening services in India, a lot of checks remain quite manual, and even where there is some technology used to help speed up the process, those results often have to be perfected via in-person checks, so looking at paper records. And this, of course, increases turnaround times, which increases time to hire. So what we have seen is that many providers, including HireRight and the vendors that we work with, are looking at how technology can be used to perform checks more quickly, and also looking to see how vendors and providers can actually start to build out databases from paper records that are gathered. Now, two good examples of this are criminal record checks and also employment checks. So in India, many criminal records have been digitised, and it's now possible to search the e-court records. And in addition to this, vendors have built scrapers and matching algorithms, which of course introduces a degree of automation into the process. In respect to employment records, we're increasingly seeing providers take those employment records that they verify and, with the approval of the referee, build out databases of those records that can then be searched or accessed. So processing of offline records and then digitising the same. In both cases, therefore, we believe the provisions of the new bill would or could apply. It's super important, therefore, that as a provider of background screening services, an audit be performed of all the current suites of checks offered to establish if they do fall within the remit of the new bill. And that also, of course, includes working with local vendors in region as they seek to digitise and automate. In respect to other preparations, this, of course, will be dependent on what type of data is processed. But to the extent that the data does fall within the scope of the new bill, any organisation that's had to prepare for legislation such as the GDPR or any of the other pieces of legislation we've discussed today, they're going to be in a great place in respect to compliance. The new bill has got several concepts that we're very familiar with and that we find in existing legislation outside of India. So, for example, providing notice of processing to individuals' rights, data breach notifications, and of course, those ubiquitous fines for getting it all wrong. However, there is one area where the new bill is divergent from existing privacy laws, and that's in respect to the permitted grounds of lawful processing. The new bill states that you can process an individual's personal data for a lawful purpose, and that means any purpose if it's not prohibited by law, if the individual has given or is deemed to have given their consent. So on the face of it, there's only one lawful ground of processing, and that is consent. But what does that mean in practice? Well, explicit consent provisions are straightforward, and this quotes directly from the bill, and means the freely given, specific, informed, and unambiguous indication of the individual's wishes by which they, by a clear affirmative action, signify agreement to the processing of their personal data for the specified purpose. However, deemed consent is more complex. And when reviewing the deemed consent provisions in the new bill, it's become clear that that's actually made up of multiple other grounds of processing that normally we'd see passed out under other legislation. So legitimate interest, public interest, etc. And in the context of background screening, we just wanted to draw out three of those limbs of deemed consent. The first is public interest, including information held in the public domain and credit scoring. The second is fair and reasonable purposes, which some of you will be more familiar of referring to as legitimate interests. And the third, and really importantly for everybody on this call, purposes related to employment, which does include recruitment. And in such cases, consent's deemed to have been given if the processing is necessary. So where does that leave us in respect to background screening? Well, I'm actually not sure it's terribly clear. On the face of it, deemed consent will cover background screening, of course, due to the call out in respect to employment, which does include recruitment. But does the caveat of that processing being necessary limit that in any way? On the one hand, it shouldn't, as there's currently no restrictions on the data that can be processed to support hiring decisions in India. So there's always going to be a lawful ground. But the question is, will we ever get to a place where certain checks would be considered not necessary, with employers being forced to consider other routes for deemed consent or falling back on explicit consent? One check where perhaps we can envisage that debate running is in relation to credit checks. There are lots of different ways to run a credit check, but it is possible that in some forms, credit scores are returned. Now, credit scores are explicitly called out under the public interest limit of deemed consent. So does it mean that that's the correct route when considering deemed consent, or could the employment limit still apply? And the reason we've drawn that out is because we find it interesting, because under the 2019 bill, it expressly carved out credit checks from the employment grounds for lawful processing. Deemed consent's also thought to raise issues when read in conjunction with one of the individual rights, and that's the right to withdraw consent. And we've been reading around some of the articles on this topic, and from what we've read, a lot of them ask the question as to whether the withdrawal of consent will apply to explicit consent only, or whether it will also include deemed consent. Now, it really seems counterintuitive to be able to withdraw consent that's been deemed to have been given. But there also isn't a provision in the draft bill to allow an individual to object to processing, which we do see in other legislations to allow an individual to challenge, for example, legitimate interests, which, as we've said, would translate potentially into fair and reasonable limit of deemed consent. So we're not sure whether or not the withdrawal of consent would apply to that deemed consent. Now, it's fair to say that all of this is a little bit of high-level intellectual debate at this stage, as simply put, we honestly just don't know the answers. But what we do believe will occur is that further legislation is going to emerge, perhaps in the form of regulations, that will clarify all of these points. And again, what we do believe is going to be the case is that the new bill, is going to be just the foundational point and the first piece of legislation of many relating to privacy in India. And of course, we will continue monitoring the progress of that bill with interest. So now we're going to look at Australia, and we wanted to focus on the Privacy Act review that's currently being undertaken in Australia. On the 16th of February of this year, the Attorney General Department of the Australian Government announced the publication of the review after 2 years of consultation on the current Australian privacy laws. The review was much needed in context of the way businesses operate today, and within the executive summary of the review, it is stated that the review aims to ensure that Australian laws are fit for purpose in an environment where Australians now live much of their lives online. Now, it's a large document. There are 116 proposed reforms. You'd be very glad to know that I'm not going to torture you with all of those 116 proposed reforms, because we'd still be here once those reforms have passed into law and perhaps beyond. But what is safe to say is that those 116 proposals are designed to broaden and clarify the information types covered by Australian laws, enhance privacy protections, in particular looking at individual rights, and strengthening enforcement. But there are some proposals that we thought might be of interest to everyone at this webinar due to the potential impact on background screening, and there's 4 of them that we're going to cover. So here we go. So under current laws, and actually there's a few more on these slides, but we are just going to cover 4 of them. So under current laws, there's actually no differentiation between parties who process data, as the Australian privacy principles, the APP, apply to all entities who hold data. Now, this can be problematic where one party processes on behalf of another and exclusively on their instructions, as it can be difficult to figure out who has ultimate responsibility for certain aspects of that processing. And that's definitely true in the background screening world. However, the reforms do propose to introduce the concept of processor and controller. And according to the review, those that submitted responses in the discussion papers in that 2-year period running up to the review were largely in favour of the distinction, as it was felt that they would assist with clarifying obligations and allocating responsibilities between entities. The paper also noted that the respondents noted that benefits of aligning with international frameworks, so New Zealand, UK, Brazil, and many others that have been called out in the review, would ensure a common understanding between global entities, and that would further enhance facilitation of global compliance. In addition, it was noted that the distinction could improve the functioning of the Act. In particular, it was felt that that distinction would clarify the concepts around consent obligations and which entity would be responsible for individual rights. And in the context of background screening, those two things are actually really important. However, on the downside, the Law Council of Australia suggested the introduction of the concept was unnecessary, which is quite bleak, and would also interfere with existing contractual arrangements, which is of course true because contracts aren't drafted on that basis at the moment. There is a lot more detail that we could go into here, and I'm not going to because, again, we could be here for many hours if we went into all of this detail. But we will just note that we have reviewed what the paper says in relation to which of the APP would apply to a controller versus a processor. And at the moment, only 2 of those APP would apply to a data processor, and that's numbers 1 and 11, and also preserving reporting requirements under the NDB scheme. All the other APP would be for the account of the controller. And again, within the review paper, it was noted that it would therefore be very important to ensure that there were specific contractual requirements within any documentation between 2 entities to actually make sure it was clear who was responsible for what. One thing, incidentally, that is missing from the review paper that we are used to seeing outside of Australia is the idea of a joint controller. And again, without that bit, a concept being included, contractual provisions, again, are going to become super important, which for any of us on this call who are lawyers is very exciting because we do love a contract. Now, there are also some submissions in the discussion paper proposed that Australia introduce lawful grounds of processing that are found in other legislation, such as the GDPR. So things, again, like public interest, legitimate interest, etc. But the review actually rejected that because it felt that it would add layers of complexity that don't actually align with the APP. So instead, what is proposed is what is being called a fair and reasonable test. And that's being put forward and would be needed in addition to any consents that are being gathered. So a test would have to be undertaken, and that is an objective test to be assessed from the perspective of a reasonable person. And the things that need to be considered are whether an individual would reasonably expect that personal information to be collected, used, or disclosed in the relevant circumstances, the kind and sensitivity and amount of personal data that's being collected, used, or disclosed, whether the collection, use, or disclosure is reasonably necessary for the functions and activities of the organisation. You have to consider the risk of unjustified adverse impact or harm on the individual, and whether the impact on privacy is proportionate to the benefit. And also, any processing to be fair and reasonable has to further the objects of the Act itself. Now, some of the commentary that we've read around this suggests that this proposal will create uncertainty on the lawful handling of personal information. And in parts, it does seem at odds to the concept of consent, because if you've consented, why do you need to also perform this reasonable and fairness test? And for background screening, we think it's going to be really interesting to see how those analyses impact the types of checks that are routinely carried out today. So as an example, if you're not in, for example, a finance team or a regulated role in the finance sector, could it ever be said that a person would reasonably expect a bankruptcy check to be carried out pre-hire, or a public financial probity check, which we know is quite common in Australia? There are further suggestions within the review about what else can be taken into consideration. So we've had a look at those to see if they're helpful. And the review notes that those considerations in terms of determining the impact on an individual's privacy need to measure whether or not things are proportionate. And those considerations that entities need to take into account are whether the collection, use, or disclosure intrudes upon the personal affairs of the affected individual to an unreasonable extent, whether there's less intrusive means of achieving the same ends at comparable cost and with comparable benefits, and then also any actions or measures that are being taken by the entity to mitigate the impacts of the loss of privacy on that individual. And again, it's that middle bullet point that may mean that if this all does come to pass, that review needs to be taken of existing screening programs, i.e. if you can do something in a less intrusive manner to achieve the same end, i.e. can you measure risk with a check that doesn't intrude quite so much on somebody's personal life, I guess. The review also recommends that privacy impact assessments should be carried out for any high-risk processing activities, but it doesn't remove the concept of the primary and secondary purpose of data collection and any rules around notification of these. Data transfers come up in the review, and a recommendation has been made to introduce mechanisms to make it easier to disclose information overseas, including the suggestion of a whitelist of countries that offer adequate protections and the introduction of standard contractual clauses. I think from a lawyer's point of view, can only hope that those standard contractual clauses are similar to those already in existence. Otherwise, it will be a real headache for departments to actually try and get all of these in place, because there'll be lots of different versions of them flying around for different data transfers. The report also introduces individual rights that align to those that we find under current EU laws, and that includes rights of erasure and objection to the collection of information. Now, anyone who's doing background screening with HireRight, all of those rights are already included in our process. So again, if they do come to pass, that's all sorted. And finally, the review suggests that employee records exemptions are removed from the legislation, though this was highly debated in all the discussion papers by those who provided submissions. So the proposals actually have pared back that full removal of the exemption and focus instead on providing transparency to employees of information handling practices, which is then having to be balanced against the employer's need to handle employee personal information for that employment relationship. Additional to this, the review acknowledges that provisions are needed for better protecting employees' personal information from being handled incorrectly, and provisions are also needed to ensure that that data is destroyed when it's no longer required. And the review does conclude on this topic that much more consultation is likely needed in relation to how privacy and workplace relations laws should interact. Now, the review publication date did only allow for 6 weeks of review, and submissions were due back on the 31st of March, and we're waiting currently to see what's going to come out of those submissions. I will finish with one final thought on the new emerging laws in Australia, and that is, whilst the proposals are still under review, we think it is worth reviewing current practices against those proposals just to get ahead of any changes and identify gaps in its current practices. And we think this is in particular important to HireRight, as if the proposals come into place in relation to processor controller, we will need to obviously review what our obligations are going forwards and any changes to contracts. So that concludes our roundup of compliance updates. And we're going to move on now to looking more in depth at our social media check. Now, traditional background checks look at actions taken by a candidate and provide great insight into their skills and qualification, as well as flagging bad behaviours. But that is the tip of the iceberg when you look to recruit. And with the focus on core values and corporate culture, it's now equally important to give consideration to how that individual is going to fit into your organisation and team, as well as their qualifications to perform a role. And social media searches do provide a much more holistic view of your candidate and give you more information to base your hiring decisions upon. But many people think that the adverse media products that have been around for some time actually include social media. Well, at least in respect to HireRight, that's actually not the case. And it is important to understand the difference between the two. So an adverse media search looks at public media sources, so publications online, to identify actions that have been taken by a candidate that are of a sufficiently adverse nature to have been reported in the public domain by third parties. However, the social media search focuses on behaviours of a candidate, and those are behaviours that the candidate has chosen to share publicly via personal accounts on a social media platform. So why is it important for employers to screen online behaviour? Well, of course, it reduces the risk of a bad hire, reduces your reputational risk, and also, of course, consequently avoids a PR disaster. In addition to that, the social media checks, if they're used on an ongoing basis, can help you monitor behaviours that otherwise could be missed by your risk teams, and that will additionally help to protect your top talent. And there are some statistics, which is hard to say, statistics to back this up. A Cornerstone survey was conducted pre-COVID, and they found that just one employee out of 20 in a team that exhibited toxic behaviours, so that's just 5% of your team, can lower productivity within the team by 40%, leaving 54% of that remaining team more likely to leave. And the collateral damage of that finding is, of course, lost time, increased cost, whether that's hiring costs or costs relating to claims in the workplace, and of course, a serious impact on corporate culture and morale. And it's particularly impactful for those teams who have been relying on those resources for example, a particular project, or that have been traditionally under-resourced. But back to the question of why use social media, which you might consider to be a little bit risky, when you can already look at that bad behaviour via adverse media. Well, you'll see 3 examples on this slide. There's a cricketer who used his Twitter account to tweet crass comments. There's a soccer player in the UK who was filmed on social media kicking a cat rather than a football. And then there was the fashion house who basically posted some anti-Semitic things on social media. Now, the reason we're drawing your attention to these is that whilst those examples were all widely reported in the press, the origin of those stories, it's important to remember, was on social media. And they went viral and were reported publicly due to the high-profile nature of the people, the posters, or the individuals that are subject to those posts. So if you're thinking of employing Stefano Gabbana, then an adverse media check is probably going to do the trick. But most folk that you hire aren't actually going to be tabloid or broadsheet fodder. However, using the social media search, depending on your search terms, and we will look at that, would pick these things up. And that brings me to the second point, which is contextualizing reported actions. Now, in the case of the 2 sporting stars, they seem to be one-off acts of idiocy, whereas the fashion house, when looked at by the journalists, had tweeted all sorts of things and posted on Instagram all sorts of things over the years, and then that got widely reported. So that was consistent behaviours that were being exhibited. Now, if those searches were only done via adverse media, the employer would only get to see the report of that one adverse action, so a snapshot in time. Whereas if you add social media, either you're doing it at the same time as your adverse media or you decide to add it on if something comes back, then that action can further be reviewed by placing those actions in context. And it allows you to review your risk of hire much more easily. So is it a repeated behaviour and one that doesn't align to your core values, meaning that you just aren't going to take the risk of that hire? Or is it a one-off action where you can manage that risk and the skills and qualifications and general demeanour of that individual mean that it's worth taking that risk on hire? And actually, as an aside, the search can actually also assist in creating, as we've mentioned, ongoing monitoring programmes post-hire that can be deployed to manage your ongoing risks, especially with high-risk individuals, or for non-risk roles, or just generally for your employee populace. You can actually use the social media check to support your ESG programs and your wellbeing programs, because you can actually search and look for behaviours or changes in behaviours that would indicate to your teams whether or not individuals need some pastoral care or extra support. So we've established that the social media check can be a good idea, but most recruiters kind of on the down low do a Google check here and there. So what are the benefits of using a product like a HireRight product? Well, a quick search to see if that candidate's posted anything can work as a one-off, but it isn't scalable. There's a huge amount of information out there, and manually searching thousands of online sources is virtually impossible to do quickly and accurately. It would take huge teams to complete the work, and that of course means steep operating costs. And additionally, manual screening can leave you vulnerable to errors and, much worse, allegations of unconscious bias in your decision making. Now, a social media search such as HireRight is designed to quickly identify those problematic behaviours for potential hires or your current employees by analysing publicly available social media profiles using automation and human analysis. And for those types of searches to be truly successful, technology has to be used to ensure robust and exhaustive searches are taking place. And you're then using AI to analyse categories and keywords to filter out everything and only report back on job relevant information. It's then important that that's all checked by a team of analysts to review the results to make sure that they are accurate. So the third most frequently question that we get is, after isn't this already in adverse media? And if I can do a Google search, why do I need to use a product such as this? Is, okay, get the benefits. I understand all of that. There's quicker turnaround times, but how on earth do you make a search like this compliant with laws? And importantly, how on earth do you get candidates to be okay with all of this? So starting at the beginning, the most important thing to be aware of, and I've mentioned it a few times, is that social media and the HireRight social media search only accesses public social media posts. It does not access or try to access any private social media. If I, as an individual, want to make my social media posts public, I can do so. But equally, I can restrict access and views and keep what I want private. And where I've chosen to do that, that must be respected. So there will never be requests for passwords to accounts. So having established that, the first task of the employer is to assess whether conducting that type of checks relevant and proportionate in context of the type of your business, your unique risk profile, and the risk profiles of the roles that you're hiring into. And the answer to this, helpfully, might be for some roles yes, and for some roles no. So the next step then is to categorize those roles via a proper risk assessment that you document into the roles that carry risk and those that don't. And there may also be that sort of in-between category as well. Now, a flexible screening program will allow you to build numerous packages to address those risks, which allows you to adopt a good level of granularity. And that's important because it will demonstrate to, for example, a regulator that you've taken all the due and proper steps to make that assessment. Let's look back at what's required or potentially going to be required under the new Australian rules around the fair and proportionate tests. So you can demonstrate that by conducting this type of risk assessment. But also as well with your candidates, you'll be able to easily demonstrate that you haven't adopted a one-size-fits-all across your organisation or across roles where it's not appropriate. And again, all of those things can be very, very helpful to demonstrate compliance. Once you've sorted all of that out, you can then move on to what you want to search, or perhaps a better way of looking at it is actually what you don't want to search for. And HireRight social media search does filter out protected characteristics and class information and focuses solely on job relevant information. And as we've mentioned, it does that quickly and efficiently by utilizing AI software that's capable of reading text and images like a human does, and then again, analyzing for job relevancy. There's two things that are important here to note. Firstly, what is relevant to a job is entirely down to you as an employer, and we'll look at how you can build out that program on the final slide. The second thing is, and we keep mentioning the technology, it is really important to use technology in this space because it significantly reduces your risk as an employer. Frequently, manual searches do inadvertently uncover information that's entirely irrelevant and illegal to use in employment decisions. So things like race, religion, sexual orientation, political affiliation. And it can become very difficult to prove that you haven't used that information in your employment decision. And even if the decision maker intends to ignore it, that information can subconsciously bias that decision maker. And it's important to note that organisations, we've just got a couple of examples here, but the US Equal Employment Opportunity Commission, the UK Equality and Human Rights Commission, and there are others, assume that if public online content is accessed, it is used. So you can't defend against that. So technology is super important there and how you build that program. Of course, you then need to find a partner that's got privacy and compliance built into its DNA, so that once that order's placed, you then have the comfort that the process itself, including how the check's communicated to the candidate, is compliant. So there's a few things that you'd need to look out for here. So the first is transparency in notifying the candidate about the nature of the search being conducted. The good partner is not only going to simply list the social media search, but it's going to include information outlining what's involved, highlighting only public posts will be reviewed, but importantly, highlighting that the parameters of the search have been set by the employer and that the employer considers the search and the parameters they've set relevant for the job that the individual is seeking. That way, obligations of fully informing candidates as to the nature and reasoning behind the processing are fulfilled. And as we know in a lot of legislation, Malaysia we've covered, India, Australia, you do need to notify folk as to why you're conducting processing. But it also has the knock-on effect of allowing the candidates to ask questions around the process before they've ever given any personal information, because that notice appears up front before personal information is requested and before this check is actually processed. And then being comfortable with that check means you'll have a smooth process going through. It's important that to back that up, there's system functionality that allows an audit trail to be collected, that the candidate's been informed about the check and acknowledged that the employer has that lawful ground for processing. It's also important to make sure your partner is storing, retaining or transferring and accessing data in accordance with requirements and that adequate security and technical measures are in place. You need to work with a partner that is able to support you to support candidates if they want to exercise their rights to access or rectify or delete data, or in fact, withdraw consent or object to processing. And HireRight has all of those processes in place to assist you. You need to make sure that the partner you're working with is filtering those results appropriately and also adequately matching those results to your candidate. And at HireRight, we use 2 known identifiers to ensure that accuracy. It's also important to limit the reporting to what's job relevant, and also important to consider whether or not you want to limit the time period in which you conduct that search. And that is possible under the HireRight product. So for example, with your grad schemes, your graduates coming through from university, you might not necessarily want to go back 7 years when they were, tweens, because I'm not entirely sure we can all be held responsible for our thoughts and what we might have liked or not liked at that age. So it may be that you want to put a shorter time period on any social media checks. And then really importantly, at the end of the process, you want to make sure that your provider does actually have a human being that's checking the matches and ensuring quality. Now, that last point is actually super important, and we haven't covered this in this particular webinar, but it's very important when we consider all the guidance that's coming out in relation to the use of artificial intelligence systems and some of the laws that are now being promulgated, for example, in the EU, because all of them do set examples where human intervention to ensure that that AI is working as it should be and putting into place checks and balances is going to be required and is important when managing AI risk. So with all of that in place, you can then concentrate on building out your program. So to help you get this right, we offer 2 main configuration options, standard and advanced configuration. And those configurations allow you to identify risk-creating behaviours related to harassment, violence, intolerance, and crime, and that's under our standard configuration, with an option to add in substance abuse, which covers drug and alcohol, under the advanced configuration. And that's important for companies in sector verticals where understanding if there's any issues with that type of abuse is important. So for example, healthcare or transportation. And the aim of those configurations is to highlight content that may introduce a toxic work environment or present a brand risk, or importantly, for example, in healthcare or transportation, the introduction of a risk to your actual services. Nobody needs people driving trains or performing operations if they have been imbibing the amber nectar, as it were. However, there is also a more custom approach to the search available. And we would say that considering the nature of the privacy laws and employment laws in region, it is really recommended that customers consider taking that custom approach. When you use that approach, you can further tailor the search criteria by using keywords. And that allows, as we've mentioned before, that really granular compliance. So alongside packages addressing different risk levels, you can also have different risk levels addressed by using customized keywords. So again, they will ensure that those protected characteristics are pre-filtered and do not appear in any results. But you can also use specific keywords that address specific risks associated with specific roles. So going back to that risk assessment that you've done, you could have a particular role type where you have one set of social media criteria running. Then you could have high-risk roles. You could have your well-being, ongoing monitoring, and you can just basically mix it all up. And again, from a regulatory perspective and from a compliance perspective with laws, that gets to the heart of the idea that checks should always be reasonable, relevant, and proportionate in context of the processing that's taking place. And in this instance, it's the risk that is created by hiring that individual into a particular role in an organisation. So finally, the last question that we get from folk is, do we actually get any hits if you're actually only looking at public posts? Well, we actually do. And on average, we're getting a 1 in 10 hit rate per customer defined criteria, which is quite high. And most of those hits, when we've analysed them with our product team, wouldn't actually be picked up in the adverse media posts. Again, we go back to this idea that most people you're hiring aren't high profile enough for their behaviour to be reported in the news. And if it is, they're probably in jail, and so won't be applying for jobs. So if we go back to that core proposition around this product, that it is analysing behaviours that impact corporate culture and reputation, the hit rate really does show that it's important that the social media check is carried out, because it means that as an organisation, when you're making your hiring decisions, You're going to be ensuring that you've got checks that make sure that person is good on paper, but also making sure that that person is going to be great in person as well. And that means teams and organizations and that individual will thrive within your organization. And that concludes our presentation today. So thank you for sticking with me, because we know that that was an awful lot of information. As Michael says, we will be following up. But now it's your turn. We've got about 5 minutes left, I think, to answer some questions. So over to Michael to ask the first question. Don't make it a hard one.
Thank you, Caroline. Thank you so much for your sharing. So I think we have 4 minutes left, and I think we have time for one question. And we received this question from the audience, and it says, are there any countries that social media search are not allowed based on local laws?
Yeah, and that's a really interesting question. And the answer to that is yes and no. More no than yes, I would say. So there aren't any provisions in any laws that say that you can't run this check. And of course, as we said, we are only running this check in relation to what's available in the public domain. So this would be publicly available information. But of course, when we look at privacy laws, what we're always looking at is whether or not the processing in and of itself is lawful and fair. So the lawful part of it is always covered by what we discussed, which is consents or having a lawful ground of processing under different laws. But you do also have to consider whether or not something's fair. And that means you do have to conduct the analysis of whether or not running a social media check is proportionate in context to the risks inherent in hiring that individual. So sort of going back to what we discussed at the beginning of the social media section, it's super important in order to comply that all entities that are considering using this or do use this type of product really do that risk assessment in respect to the people that they want to push through social media, and that they do categorize those roles and analyze that risk. And as we say, you can actually build the program so that the different risks of those roles can be taken into account. You can build different packages so that you're not putting social media in every single screen that you do. And of course, this configuration, again, allows you to demonstrate actively that you have taken due and proper consideration of what's relevant and proportionate. And that way, albeit, as I say, there are no direct prohibitions, there are standards that you do need to sort of adhere to under that privacy legislation. And taking all of those steps, albeit it takes a lot longer than just sort of rolling something out, means that you can be satisfied that you can demonstrate that you are attempting to comply with those laws. Of course, anything and everything can always be challenged. And that's, again, why we say it's so important from the candidate perspective to have those processes in place, that if a candidate challenges or withdraws consent, that's easily done, essentially. And again, our processes back that up. So there's lots of different steps to take to ensure compliance, but no, there's no actual prohibitions under those local laws.
Thank you, Caroline, for the answer. I guess we are at the top of the hour, and if your question hasn't been answered yet, not to worry, we will get back to you shortly. And for recording related questions, we will also get back to you individually. And once again, we would like to thank Caroline for your insightful sharing, and to all attendees for your participation. So we hope you enjoyed today's session, and goodbye for now, and see you soon. Thank you.